CR1 is now in session.
Please be seated. This is the time set for oral argument in 1 CACV 23-0632, Young Acres, Inc. et al. Versus Gary C. Mortimer et al. As a reminder, this hearing is being video and audio recorded. In a few days, the video will be posted to our YouTube channel. So, counsel, before you begin your argument, please identify yourself and the party you represent. Each side will have 20 minutes. If the appellant's counsel would like to reserve time for rebuttal, you're certainly free to do that, but you're responsible for keeping track of your own time. We have read the briefs and conferenced the case, so we are familiar with the issues. There's no need to repeat what's in your briefing. Counsel, if you'd like to begin.
May it please the court, Andy Harnish and Eric Moats from the law firm May Potenza, Barron & Gillespie, and we represent the appellants in this case, Young's Farm and Young Acres. And before I begin, I'll tell the court that I do intend to reserve approximately 5 minutes for rebuttal. Your Honors, one could be forgiven for thinking that this is a case about water law, but that would be a mistake. The question before you is about what rights survive a deed of trust sale in Arizona. And specifically, the question is whether a senior recorded interest in property survives the foreclosure of a junior interest in that property. Our statutes provide a clear answer.
Before we get to the sale, counsel, the deed of trust in favor of First United was recorded in January 2007, correct?
I believe that's correct, Your Honor.
And is there anything in the record to indicate that at that time your clients objected that the deed was erroneous, overly broad, anything of that sort?
No, Your Honor. I don't know how my clients would have. I don't think that the owners of senior interests in property are charged with monitoring what gets recorded that's junior to their interest. So the answer to your question specifically is no. There's nothing in the record that shows that they objected to the scope of the deed of trust. And our view, I think, as you saw in our papers, is that the scope of the deed of trust doesn't purport to encumber the surface water rights that are at issue in this case, nor could the trustor have conveyed those rights in trust.
Okay, but the scope of the deed of trust includes water and water rights now or hereafter flowing through or pertaining to the land, correct?
Well,
it's broad.
That language, I would agree with you, is broad. However, before that, it specifically contains a grant which says the trustor grants all of the trustor's interest in the following property. So it specifically only relates to property that the trustor has a right to convey. At the time that Yavapai executed the First United Deed of Trust, it had never had any rights to the surface water rights that are at issue here. So the deed of trust by definition only conveys what the trustor had to convey, and in this case the trustor could not have conveyed the surface water rights that are at issue here. And we also think that I think that that's enough to answer Your Honor's question about whether it purported to convey those, because it only purported to convey what the trustor had to convey. However, as we noted in our papers, there were also carve-outs within that deed of trust, which included claims and title to water. So those were expressly carved out from the grant as well. Your Honors, probably the key statute for you to interpret here is Arizona Revised Statute 33-811E, because that's the statute which unequivocally states that a deed of trust sale extinguishes rights that are junior to the foreclosing lender and preserves rights that are senior to the foreclosing lender. In this case, the Superior Court correctly found that the Youngs properly reserved title to certain surface water rights when they sold their property to Yavapai. And that's based on an undisputed fact, which is that reservation is set forth in a recorded deed. That deed is in the chain of title for the property. Another undisputed fact, the deed of trust that was foreclosed here was executed and recorded later in time than the deed in which the Youngs retained title to the surface water rights. The foreclosed deed of trust was junior to my client's title to the surface water rights. As I noted a moment ago, there's two important things that follow from that. Number one, those rights did not belong to Yavapai when it executed the deed of trust and therefore could not have conveyed them in trust. Two, the trustee of the deed of trust did not possess legal or equitable title to the surface water rights and therefore had no ability under Arizona law to convey them to the buyers, in this case, the Mortimers. So everything we've discussed up until now is a fairly straightforward matter of Arizona law, and there's little dispute about it in this case. The trial court got all of that right in its summary judgment order. Where the trial court went wrong is where it ruled that even though the Youngs had superior title to the surface water rights, the trustee nevertheless purported to convey those rights in the trustee deed, and that conveyance was effective. What the court below found was that the trustee conducted a defective sale because he purported to sell something that he had no right to sell. Now, the problem with that is the trustee didn't say anything to the effect of, I am going to sell the following described property along with all of the surface water rights that attach to that property.
But it didn't exclude them either.
That's correct, Your Honor. So we know that both the notice of trustee sale and the trustee's deed contain a general metes and bounds description.
But if it had specifically said including all water rights, you would agree that your client would have had to have gone in and objected?
That's a much more difficult case for my clients. If it had purported to specifically sell these surface water rights, then that sets up a conflict between two of our deed of trust statutes. The one that says you can only convey things that are equal to or junior to the foreclosing interest. The other statute which says that the recorded trustee's deed is essentially a final adjudication of any objections that a party can have to the sale. So,
but what would be the argument if it says that we are conveying all water rights, pertinent or whatever we're going to say about it, all water rights are included as part of this sale, even though you've got something recorded? Aren't you under an obligation to come in and don't you waive it by not objecting?
I think in that case, Your Honor, there's a very strong argument that my client was under an obligation to show up and try to enjoin that sale before it, because it purported to sell something that the trustee was not allowed to sell. So that's very much like some of the cases that have been cited to you. There's a case called Zubia, which is a Arizona Supreme Court case. And there were two other cases that were cited by the other side, which were unpublished decisions, but they all kind of have the same thrust, which is as follows. If the trustee purports to sell something that he's not entitled to sell, that's the Easy Homes case, the unpublished decision that was cited. In that case, the property description that was included with the trustee's notice of sale included property that belonged to an adjoining landowner. In that case, the landowner came after the sale occurred and tried to undo the sale. And in that case, the court said, if you receive notice and if it purports to sell something that belongs to you, you're now objecting to the sale itself, and that's barred. That's not the situation that we have here, because here the trustee did not purport to sell something that he didn't have an obligation to sell.
Unless you read it as, I'm selling this land, and we assume the water rents. I'm interested in your take on the Norwest Bank case.
Right. Yes, and that's what the appellees would have you read, that a general description includes essentially everything that would be appurtenant to the property. So
why doesn't that make sense, though?
Right. It makes sense. So the general rule in Arizona is that a conveyance of the property is presumed to be in fee simple, which means everyone remembers the bundle of sticks analogy. You're presumed to be getting the entire bundle of sticks, but Arizona law is very clear that a property owner may convey all or some of the bundle of sticks when it transfers the property to another landowner. So you can retain an easement, you can retain mineral rights, grazing rights, surface water rights. That's what happened here.
But what in the deed of trust that's being foreclosed at the trustee's sale puts someone on notice that they are not obtaining the water rights that go along with the land?
What our view is that a buyer is charged with knowledge of what's in the chain of title, just like any other buyer. And so in this case, even though there's a general rule that a buyer gets the entire bundle of sticks, in the chain of title in this case, my clients reserved a property right and did not transfer it down the chain of title. And so that's allowed under Arizona statutory law. And there's the Phoenix title case, which is the Supreme Court case from 1966, which says not only is it legitimate to transfer some but not all of your property rights, but that transfer is valid and enforceable against subsequent purchasers of the same property. So once it's reserved, that's a right that's personal to my client, and it doesn't get transferred with subsequent
That one doesn't involve a
transferees.
trustee's sale, though, does it?
That one does not involve a trustee sale.
Does that matter where you send notice to people and we say if you think there's a problem with this, weigh in before the trustee's sale or forever hold your peace?
Your Honor, I think the answer to your question lies in Section 33-811E, which says that all a buyer can hope to get from a trustee sale is the foreclosing lender's interest and everything junior. And they're not entitled to expect to receive anything that is senior to the foreclosing interest. And to hold otherwise would turn what is supposed to be a streamlined non-judicial foreclosure procedure into a quagmire of litigation, because to so hold would be to tell senior interest holders, perhaps an easement holder who has had something for decades, that you need to monitor every trustee sale that touches upon your collateral, because if...
But this isn't just monitoring, you're getting actual notice of it. Isn't that different? Wouldn't that create some kind of obligation? I mean, after the sale goes through, your client goes and says, it looks like there's a question about whether you got some water rights that we don't think you're entitled to, so we want you to sign this quitclaim deed. If you notice that after the sale, why not notice it? And you receive notice before, why not go in ahead of time and get an injunction to stop the sale?
Right, so Your Honor, so in every trustee sale, my understanding is that anyone with an interest in the property is required to receive notice from the trustee, senior and junior. And so in my hypothetical, if I'm a holder of a utility easement or something, I'll receive the notice, but it would be pernicious to hold that if I receive a notice and I think that there's any ambiguity or it says, this doesn't say anything about my easement, and so I better go to court and get an injunction. That turns what should be a streamlined procedure into essentially every foreclosure is a judicial foreclosure, which is not what's intended by the statutes. And so our view is that we have a statute which says if you're a senior interest holder, your interest is protected because the trustee can't transfer your interest. Our view is that senior interest holders should be entitled to rely on the statute that the legislature put in place to try to streamline this process. So Your Honor asked about Norwest. I want to make sure that I address that, because the trial court ruling relied heavily on what we think is a flawed reading of the Norwest case. So Norwest stands for the proposition that a foreclosing lender loses all of its own interest in a property when it conducts a deed of trust sale. In this case, the court below expanded the holding of Norwest to state that a deed of trust sale transfers senior rights that are pertinent to the property unless they're specifically carved out. We think that's in conflict with the statutory and the case law that we've already discussed, but it's also not consistent with Norwest itself. The facts of that case are you had a bank who lent money and took a lien on a piece of commercial property and recorded two instruments to secure its interest in that property, a deed of trust and a separate assignment of rents. There was a default on the loan, and the lender caused a deed of trust sale to be noticed under the deed of trust, made no mention of the assignment of rents that it also held, conducted the deed of trust sale, borrower came in and owned the property and started operating it as commercial property, and then the lender later showed up and said, aha, I foreclosed my deed of trust, but I never foreclosed my assignment of rents. So you, new buyer, still have to pay over the rents you received from this property until my loan is satisfied. What the Court of Appeals in Norwest said was, and this conforms to the statutory and case law perfectly, which is the interest of the trustor, the trustee, and the beneficiary, in this case the beneficiary of the bank, is extinguished in a trustee sale. All of its interest is extinguished in a trustee sale. So you don't get to foreclose one of your collateral packages but retain another one if you choose to conduct a trustee sale. That is not in conflict with our position in this case. Our position is, in this case, is that that trustee sale does not disturb the interests of senior interest holders. So that's where we think that the trial court got Norwest wrong. I'm mindful that I have about 4.5 minutes left, but if there are any other questions that your honors have, I'd like to address them now. I'd like to reserve the rest of my time.
Thank you.
May it please the court, Timothy Berg of Fenimore Craig, on behalf of Appalese. This case was properly decided based on a straightforward application of a portion of the deed of trust statutes of the state, ARS 33-811C, to the undisputed facts of how the Mortimers purchased their property at a trustee sale. It's a situation that's been faced by this court in a number of cases, but probably the most on-point case is EZ Homes versus LaSalle, and I may be saying that last name wrong, where in a memorandum decision, this court concluded that a challenge to a trustee sale not only covers challenges to the mechanics of the sale or the notice provisions, but it also covers a challenge to what is sold. In other words, if you want to challenge what someone buys at a deed of trust sale, you have to file the action ahead of time under 811C. That's what this court...
Does that apply when there's something that's recorded that reflects a senior lien or a senior interest in the property?
I refer the court to the main one limited partnership case, 154 Arizona 256. It's cited in our briefs. If I read that too quickly, I apologize. Which says for purposes of 811C, it doesn't matter if there's a recorded prior interest. What matters is whether the purchaser at the trustee sale had actual knowledge of the prior interest.
Why don't you have actual notice of something that's recorded? You don't look through the chain of title.
Your Honor, I mean, the idea of recording is to give people constructive notice. Actual notice it depends on what they knew, and there's nothing in the record here that indicates that my clients knew about this purported water rights reservation until after the deed of trust sale when they bought the property and
So if there were letters to them before the trustee's sale saying this is something that's been reserved, this is not included. Our view, if Young had sent that, then you would agree then that the trustee sale could be set aside?
No, not necessarily. I think just if the Young said something, just sent them a letter saying we have a claim here. I'm not sure that does it, but certainly where they have no knowledge of the recorded instrument and they have no knowledge of the claim, which is the easy case here, there can't be, the constructive notice simply doesn't bar them under the main one limited partnership case.
Counsel, let me just take a step back.
Sure.
The deed of trust in favor of First United, it seems to me was broadly worded. Is there anything in the record to indicate that the appellants objected at that time to what was included in the scope? And if so, does that have any significance?
There's nothing in the record as far as I know, Your Honor, that indicates that they objected. And again, Under the Norwest case, I think the answer here is that the trustee's notice which gives a description of the property to be sold at the deed of trust sale is controlling. And that's because of 33808A. Once the notice goes out and says, this is what I'm selling, and as the court has pointed out, Mr. Harnish was up here, it included water rights, then that governs. If you don't like that description, you have a remedy. You go to court and you get an injunction to stop the sale before 5 p.m. Mountain Standard Time on the day before the sale is scheduled.
Mr. Berg, what about counsel's argument 33811E? Will you bring that into
I think 38811E, try it this way. If you look at, I think it's 33809, you have to give notice to everybody who has an interest in the property. There would be no reason to give notice to prior right holders if Mr. Harnish's right in the sale can't possibly affect them. Why would you have to give notice to somebody of a sale that can't affect them? What it can do in a case like this, where somebody claims they own part of the property that's being sold, then once they get that notice with a legal description, and it doesn't include the exception of their property, then that property is sold as part of the trustee sale because the trustee's deed controls at that point, Your Honor. 811E simply does not preserve a right of someone to argue. Let's say we have Blackacre, and Blackacre has 3 lots to it, 1, 2, and 3. What you can't do under 811E is say, look, I reserved lot 3 in a previous reservation, a deed I gave somebody. If the trustee sale says, I'm selling Blackacre, and lists some exceptions, and it listed exceptions to property here in the legal description, but not the water rights, then you, as a holder of a senior interest or junior interest, as a holder of any interest that is junior to the property, to the, I'm sorry, try again. If you hold an interest, you claim you hold an interest in the property and it's not listed in the trustee's sale notice, then you have an obligation to protect your rights by filing suit under 811C. That's what 811C says. Why does it say that? I think the best answer to that question, Your Honor, is in paragraphs 29 and 30 of the Norwest case. I'm reading you from 30. ARS 33808 directs the trustee to specify what property the purchaser can expect from the trustee's sale. The policy which animates this provision will be seriously undercut with the trial court ruling here, which was that some of the property didn't get sold, the fellow held back the rent assessment, were applied. The purpose, I agree with Mr. Harnish on one thing. The purpose of a trustee's sale is to have a simple, easy way to foreclose. And that simple, easy way to foreclose operates the way it does because, one, you have a deed of trust, you have a notice that describes the property being sold. If someone objects to that description, they get to file a lawsuit. If they don't and the property is sold under that legal description, it binds everyone. It binds anyone who claims to own the property itself.
Does it have to be an ownership? I understand that the Youngs are suggesting they actually have an ownership interest in the property to the extent that they own water rights.
Right.
If it's just an easement across the property, I hold an easement. Do I have to go in and object?
I think you do if the easement's not listed. If you look at the legal description in this case, it lists easements. It says accepting an easement for utilities, accepting a portion of the property for some other purpose. Normally, legal descriptions list easements. And I think if you came in and you saw, let's say you were the neighbor and you thought you had an easement for a driveway, I think if you don't see your easement for the driveway listed, then you probably ought to go to court and get the question of whether you have that easement vindicated. But certainly where you claim to own the property itself, or a portion of the property itself, which is what these folks claim, then you absolutely have to go to court because the legal description of what's being conveyed controls, and it doesn't include an exception for the property interest you claim. Mr. Harnish raised a few points, and I want to cover those. First, he said, well, if you do this, if you read the statutes the way the appellees want, then every senior right holder has to be on guard and watch for all trustee sale. As the court pointed out, that's simply not how this works. What happens is everybody, including a senior right holder or somebody claiming title to part of the property, gets notice. Why do they get notice? So that they can comply with 811C. They can read the notice of trustee sale, they can see what's being conveyed, and if they think that their interest is not protected, they can go to court, and the court tells them they have to do it and they have to get an injunction before the sale happens. He talks about how in the deed of trust there's a carve-out for the water rights. That's simply a misreading of the deed of trust. The carve-out he's talking about has to do with what the seller will defend in terms of title. And under the Phoenix title case, this is the older Phoenix title case, the one at 31 Arizona, it's at page 331, it's clear that just because you accept something from a warranty of title, that doesn't accept it from the grant. You've got to look at the granting language to decide what was granted and look at the exception language to look at what's held. But just because I reserve, because I don't warrant title doesn't mean I haven't conveyed it. If it were true that everything I didn't warrant title to was never conveyed, a quitclaim deed would never be any good. I could give you a quitclaim deed, I've not warranted title to any of it, and at least the extension of his position would be the quitclaim deed's no good. I haven't conveyed anything to you. We all know that's not right. Moving to the water issue briefly. The trial court got much of this case right on the trustee sale side. He got it wrong on the water side. What plaintiffs what appellants purportedly reserved was a right in surface water. And they separated the ownership of the land from the ownership of the surface water. They can't do that. Under the cases we cite, including I think it's Gillespie and Schlosser, you cannot take a surface water right and separate the ownership of the water right from the ownership of the property. Why? Because in Arizona, water has to be put to beneficial use. What happens if they could do what they said they could do? What would happen is the Youngs would own a right which they can't use because it's pertinent to property they don't own. The property owner who does own it wouldn't have water rights. What eventually would happen is that the Youngs would forfeit the use of their water right under the statutes because they couldn't use it. They have a water right that can only be used on property they don't own. That makes no sense. What makes sense is to recognize that what these courts have held since at least 1919, which isn't quite statehood but close to it, is that water rights in surface water belong to the property, not to the individual, and you can't sever them.
Is the court's ruling simply that in this instance there appeared to be an agreement that we're going to work with the state to figure out how to change how the water is used on the property, maybe it's for municipal purposes, or there will be a change. We're going to work together, and once that's done, if that's accomplished, then you're going to owe us more money. Is that a fair assessment of what they're
I think
trying
that's a
to
fair
do?
description of the
And is the
transaction.
court just saying it's okay for you to have an agreement to do that?
I think, Your Honor, it may be okay for you to have an agreement to do that, but it doesn't give the person who purportedly reserved the water right title to the water. The water has to stay with the property unless and until you get it severed under the statutory proceeding. And the Department of Water Resources, during the severance proceedings here, pointed out to the parties, the appellants and YLH, repeatedly that the water right had to go with the property, that the transfer could only occur if there was in fact a transfer from the Youngs to their buyer, that the Youngs couldn't own a floating water right out there, separate and apart from ownership of the property. And again, of course they can't, because it's inconsistent with the doctrine of beneficial use. If plaintiff's position is correct, I could go out, buy a bunch of land, hold the water rights, sever the water rights, hold on to them, make the property essentially worthless, have the water not be used anywhere because it can't be used anywhere except the property. And that's wholly inconsistent with the idea in Arizona that a purpose of our whole water law is to assure that the most beneficial use that can be made is made of surface water. In a sense, what the plaintiffs come to one of 2 points. Either they're saying we can hold it and sell it to use another piece of property, which clearly is wrong, because then you'd have to get a severance and transfer, or they're saying we can hold this and just keep it from being used on the property. And that's wrong, because again, the water right goes with the property, not with the owner of the property.
Can we address the issue without having Yavapai be a party to the proceeding?
Yes, I think you can, Your Honor, because if in fact the water right reservation is invalid, then the water went with the property first to Yavapai and then to my clients at the deed of trust sale. You don't need to have Yavapai to be a party to decide that.
But if we were to decide against them, wouldn't they want to be heard on that? Wouldn't it affect the relationship between Young and Yavapai?
I don't think so, Your Honor. First of all, Yavapai hasn't appeared in this case and failed to make an appearance, even though they were sued in this case. Secondly, I think the answer is if Yavapai's title is ultimately, assuming, well, start one. Nobody is claiming Yavapai owns the water rights here. These folks are claiming the Youngs own it because they reserved it. We're claiming the Mortimers own it because they bought it at a trustee sale. Yavapai hasn't ever raised the issue of owning the water rights, and none of us are taking the position they own them. So I don't think you need to have them here to adjudicate as between their claim that they own it by virtue of the reservation and our claim we own it by virtue of the trustee sale. And if they couldn't reserve it in the first place, then it goes with the land anyway, and whoever owns the land owns the water right, and at this point my clients own the land.
But if you own it by virtue of the trustee sale, then you don't really care.
Right. The judgment was appropriate for us in 2 different ways. One, because the trustee sale conveyed title to the property, including the water rights to the Mortimers. Or it's appropriate because 2, they couldn't reserve the water rights in the first place because that's an illegal reservation. And therefore the water stayed with the land and we purchased it at the trustee sale because it was never reserved in the first place. They either had a reservation that was extinguished by the trustee sale or they never had a reservation at all and the water was sold at the trustee sale.
But you're saying if the trustee sale, if the document had said we're selling this land without the water rights, and your client had purchased it, could you come in and say, well, even though the deed says that was foreclosed said it didn't include water rights, I'm entitled to them because this was an illegal.
I think you could make that argument, Your Honor, absolutely. But you don't need to here because the trustee sale didn't accept the water rights. I mean, basically, I say you get there 2 different ways, and one is by deep virtue of the trustee sale and what it sells. The other is by virtue of the fact that you can't create an illegal interest in property. Just like you can't create an illegal restrictive covenant, you can't create an illegal water rights reservation. And a water right reservation that severs the surface water rights from the underlying property to which it applies and which it was appropriate for is illegal. I want to cover one more. I have a couple minutes to cover one more point. Mr. Harnish in his reply brief argued that, Mortimers can't raise the argument about water rights because they didn't file a cross appeal. If you look at Arizona Rule of Civil Appellate Procedure 13B2, it is pretty clear, I think, that we did not need to file a cross appeal. What it says is the party's answering brief may include a statement of issues presented and may discuss any argument issue properly presented to the Superior Court without need for a cross appeal, and the appellate court may affirm the judgment based on any such grounds. An appellate court, however, may modify a judgment to enlarge the rights of the appellee or to reduce the rights of the appellant only if the appellee has filed a notice of cross appeal. We don't want the judgment to be modified. We've not asked for any modification of the judgment to reduce their rights or expand ours. We want the judgment to be affirmed All we have done is given you an additional ground for affirming it. And if you read those two sentences of 13B2, it's clear we can do that by cross issue. If we're asking you for more attorneys, if we're asking you to somehow give us more rights, then I think they would have a legitimate argument. But that's not what we're doing. We're simply asking you to affirm the judgment. The rule is clear on its face. It didn't used to be. This is a rule that was adopted, shows how long I've been practicing law, relatively recently. It wasn't long when I started. It was very unclear what was a cross appeal and what was a cross issue. But now I think it's very clear. It's a cross appeal if you want to modify the judgment. It's a cross issue if you just want to affirm it. And that's all we've asked for. If the court has no further questions, thank you very much.
Thank you.
Your Honors, Andy Harnish once again for the appellant. As it relates to the foreclosure issue, the crux of this case that you need to decide is, was the deed of trust sale defective? Because all of appellee's arguments and indeed the basis of the trial court's decision is premised upon the idea that this was a defective sale that was conducted by the trustee. When Mr. Berg talks about the Main One limited partnership case and the Easy Homes case, in both, so the Main One case is the one that has the language that talks about a party who purchases takes it notwithstanding the defectiveness of the sale unless they have actual notice of the defect. So again, the Main One case is inapplicable here unless you find that the trial court got it right, that the trustee got something wrong here. The Easy Homes case likewise talks about if a party wants to challenge something that was sold in the sale, you have to appear and object to the sale before the sale occurs. Once again, our view is that the trustee did not conduct a defective sale because the trustee did not purport to transfer anything that he wasn't authorized to transfer.
But what about the argument that's been made is your client is essentially asserting an ownership interest in the property. You're asserting an ownership. It's like there's three parcels. You're asserting an ownership over one of the parcels, and all three parcels are being sold. Isn't the case law pretty clear that you have to come in and object if it says we're selling all three parcels?
I think if you look at the notice of trustee sale itself, that analogy is inapplicable here because it's not as if, so that's the Easy Homes case, right? The Easy Homes case is there's a lien on parcel one and the trustee says, I'm going to sell parcel one and parcel two. And the owner of parcel two doesn't show up and object. That's not what happened here. In this case, the trustee says, I'm going to exercise my right to sell the trust property in this case. Now, what was the trust property? It did not include my client's interest in the surface water rights. My client had validly reserved title to those surface water rights, and the trustee didn't purport to transfer them. And in fact, what the trustee purported to do was only and exactly what he was allowed to do under Arizona law, because if you look at the trustee's deed itself, it says trustor conveys this property under the power of sale under the deed of trust and in accordance with Arizona Revised Statute 811.
Isn't this inconsistent with the demand letter that your client sent to the Mortimers, which said that the trustee's deed purports to transfer title to the property without any exception for Young's continuing interest in water rights?
So I think what the record contains, Your Honor, is that after the trustee sale took place, the first thing that the Youngs did was send a letter asking them to comply with the contractual obligations of the prior landowner, Yavapai. And after that, the Mortimers, through counsel, wrote back and said, not only are we not going to comply with your contract with the former landowner, but we own these surface water rights and you don't have any continuing interest in them. And so that's what teed up this dispute, is shortly after the trustee sale took place, in which my client felt like it was secure in its continuing title to those surface water rights, then there became a dispute between the parties over what the effect of that sale was. So, Your Honor, that was what put us on notice. I want to use my few remaining seconds just to highlight, because I'm not going to be able to get into the surface water rights issue, the severance and transfer issue. We think it's well briefed. But Appellate Rule 13B requires a cross appeal to be filed if they want you to affirm on a basis that would reduce my client's rights. In this case, the trial court held that, based upon his ruling, we still had a right to pursue Yavapai, who is another defendant, for breach of contract for losing these rights that properly belong to us.
Counsel, your time is up.
Thank you, Your Honor.
All right, thank you. Counsel, thank you for your presentation. We'll take the matter under advisement and issue our ruling in due course.